Welcome to Legal Talk, a conversation about governance issues that New York's co-op and condo boards are tackling today. I'm Carol Ott with Habitat, the New York City magazine for co-op and condo board directors. My guest today is Matthew Smith, a senior associate at the law firm Smith, Buss & Jacobs. At one time or other, most buildings in New York need to be worked on. Whether it's the roof, the facade, windows, you name it, it's something. So it's no surprise when a neighboring building knocks on your door, figuratively speaking, and says it needs access on or over your building so its workers can set up. Matthew, what should your response be?
Your response should be yes, but with some conditions and with a proper access agreement in place.
And tell me sort of how that works and what are the key points a building has to have in an access agreement?
You want to make sure your access agreement describes exactly what work the neighbor plans on doing and where. We recommend that you ask for drawings and specifications if they're available. You want to know how long their project's going to take and how long they're going to need access to your property. You're going to want to require that the neighbor and its contractors indemnify you against any damages or costs that their access creates. And of course, you're going to want to require proper insurance.
Could you just explain to me when the indemnification process? I'm not sure I quite understand what that means.
Sure. The neighbor is required to reimburse you against any damages that you might incur. And that includes liability that might occur if anyone gets injured or if their access or their project causes damages to someone, including you and your building.
And if I'm going to sign such an agreement, does the access agreement come with a money payment?
Often it does. The neighbor has to reimburse you for any costs that you might incur, and that would include engineering costs, architect's costs, and lawyer's costs for the access agreement. There's reimbursement if there's any damages to your building or to any of the residents of your building. And there's often a license fee for loss of use of a portion of your property. And all of that can be negotiated with the neighbor.
And often if the neighbor wants access to your building, and I suspect this has something to do with the sophistication of the buildings. I mean, I set it up that, somebody's going to knock on your door, but in fact, they're not having workers standing there and knocking on the door saying, we need access to your roof. Are they?
Sometimes they are, or sometimes they try to start installing scaffolding or some such on your property without asking for permission. So you do want to engage the neighbor first and say, please wait. There are certain conditions that have to be met, and we need to have an agreement about how this is going to happen.
If a building notices that a neighboring building is bringing workers on, or maybe has set up a shed or sees activity, does it make sense for that building to be proactive and knock on the neighbor's door and say, do you think you're going to need access to my building?
Of course. Cooperation is the key with this. No one wants to hold up the project, either of the neighbors, because the project is an inconvenience for both. So cooperation is key, and addressing any access issues first is critical in making sure there are no delays and everyone is protected.
So let me just ask you, where are the areas where things can go wrong?
Well, things can go wrong if the project takes too long, if scaffolding and other protections are left in place longer than they were expected to be in place, if you lose access to portions of your building, to balconies, to courtyards, to alleyways, things of that nature. That's why the access agreement is critical. It should address all of those probabilities and have some sort of mechanism for the two neighbors to sort it out.
And let me just sort of finally ask, who are the professionals involved in crafting? I mean, I know it's lawyers, crafting the access agreements, but are there other professionals involved?
Depending on the scope of the work, there would be engineers or architects involved. We lawyers wouldn't know necessarily what protections need to be in place for vibrations and for measuring and keeping track of damages that might occur. So often there are costs involved with retaining an engineer to review the scope and whatever the specifications are for the work that might be occurring. And that engineer will help guide the lawyer in putting the proper protections in the access agreement.
And the building that provides access, Do they need, or would you recommend that they have a architect or engineer double check that when the job is done, there hasn't been damage to their building?
Yes, we would. And often the access agreement will have a provision that photographs or videos, some sort of investigation is done before anything is installed to show what the state of the building was before any access was given. So after the project is done and protections are removed or scaffolding is removed, there can be a review then by an engineer or others to show if any damage has occurred.
Okay. So, sort of finally, what is the takeaway for boards when their neighbors ask for access?
I think the takeaway is that neighbors are required to cooperate with access for necessary repairs and maintenance. So do cooperate, but do it with reasonable conditions and do it with a written agreement so that there are proper protections for you and no misunderstandings between the neighbors.
All right. Thank you so much for talking to me today.
Thank you, Carol.